Hey everybody on YouTube, how's it going? We're going to start here in a few minutes. We're going to talk about dealing with these courts, how to get your case dismissed. They can only talk to fictions. So we'll talk about that here in a few minutes.
All day, and so I'm just here to listen, really. But push comes to shove, I'll do what I need to.
Okay, sounds good. Thank you. Hey, Glenn.
Hi, how's it going?
It's going. How's it going by you?
Well, learning a few more things. I think that affidavit of life, that was going to be my next step, is is introduce. I was going to remove this case into federal court as a counterclaim and war crimes. And since I had an affidavit of life filed into another case in the federal court, then I was going to introduce that as exculpatory evidence. And anyways, I think they knew where I was going with it, and so they just dismissed everything.
Everything is dismissed now?
Yep.
That's awesome.
Yeah, they dismissed it. That's the reason they kicked me out of jail. And they went and um, they released the bond. There was a $500,000 bond, and so we're gonna actually go there and talk about settling the matter. And I think I should be able to get a settlement out of them. Think they screwed up. So we'll see. I don't want to talk about that too much on the public, but we're going to go and tell them that we want to settle the matter, that we've been damaged, and we want some compensation, and we'd like to be at peace. So we'll see. But so what I wanted to talk about today is affidavit of life, and what you need to do is introduce that as exculpatory evidence and have an evidentiary hearing and introduces as exculpatory evidence, and that'll be like major problem for them.
Well, from what I know, you need to have it filed with the probate, the Secretary of State, and the Attorney General as well.
Maybe, I
And
don't
your
know. I
county
don't see why
recorder.
you can't introduce it into a case as exculpatory evidence.
Well, I'm not saying you can't, but if you file it in those other places, then it's there's no question because it's the probate court, from what I know.
Well, yeah, I would agree.
So, Glenn, I have everybody coming in and I have them all set to be muted so you don't have any interruptions. So they'll have to raise their hands to ask questions, or do you want them to have open mics?
No, it'd be better to, I don't want anybody walking all over me. And if they have a question, I'll at the right time, I'll entertain questions. Right now, we're live streaming on YouTube, and YouTube can't introduce or can't interrupt anybody, and so interruptions are not appropriate.
Okay, that's what I thought. So I'll just wait a few minutes and then I'll hit record and introduce you.
That's fine.
Hey, Glenn,
Yo,
is your mic open on YouTube?
it is.
Can you shut it for a minute?
Um,
You have that option there?
well, if I shut it, I'll probably shut it for everybody. Let me see
Oh,
what
you
I
don't
can
have
do.
like a mic to open or close?
I'm looking. I don't normally turn it off or mute it. I can shut it on my computer, but that'll shut it for everybody.
All right. Well, uh, there's a couple of people. I'm getting messages because this is not a public group. You're showing on your screen on YouTube the group here.
Yeah.
Do you have like a backdrop that you can put up instead of the group?
Um, I could, I suppose, if you don't want them to see the group on YouTube.
Well, they're not members here. Not all of them, I should say. And it is a private group. And also, people have been questioning me about the Bivens because you got to open over there, which is public, and here it's not.
Well, I'm not sure if I can share. Like, I want to go through this affidavit of life here today that's filed in the federal court, and I'm not sure. Document 113. I'm not sure if I can share it on YouTube without sharing it. I mean, I'm not sure I can share it with you guys without sharing it on YouTube.
No. That's not the problem. That's not the problem. The problem is you're showing the private group with all the different subtopics within the group.
I'm showing what?
You're showing the We Are the Law Telegram group with the subtopics, which it's a private group.
I'm showing the people. The people are, they're seeing the people that are in the chat on Telegram, uh, along with the document. They're not. I'm not showing the subtopics. They're not seeing that.
Okay.
They're seeing. Matter of fact, they're seeing what you're seeing right now. And you're seeing. You should be seeing my affidavit of life that says filed in the U.S. District Court. And the chat, the private group chat, the people on the side, that's all you should be seeing right now. And that's all that's showing on YouTube.
Okay. That's not the picture someone sent me.
Well, it was showing the subtopics earlier,
Okay.
but I put this up, and and this is what will be seen until I take it down. I'll see if I can't have something else to put up to replace it.
Okay. Yeah, that's fine. So, with your knowledge on the Bivens, Glenn, should it be read, being that you're broadcasting it publicly?
Well, it's up to you.
Well, it's up to you, really. I'm asking you, you know? Your call.
Okay, well, go ahead and read it then.
All right, let me hit record. Start recording. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? This is also for a notary, poll worker, school board member, anybody who signed an oath to the de facto government. Raise your hand, say your name, state, and position. Second reading. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? You could be a notary, poll worker, school board member, anybody who signed an oath to de facto government. Just raise your hand, say your name, state, and position. Last and final reading. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? This is also for a notary, poll worker, school board member, anyone who signed an oath to de facto government. Raise your hand, say your name, state, and position. Okay, Glenn, welcome on. You got the mic. It's all yours. Look forward to listening.
Okay, I was going to talk about what you can do to any court case that you're dealing with. What you're seeing right now is a filed document that was filed into the federal court. You can see the filing stamps, the page headers they put on there, all of that stuff. And but we're not going to go through that in detail, or in a lot of. We're going to go through the Word file, and the Word file is available for anybody that wants it, so that you can make your own. And the reason you want to file this into the courts and get it out as much as you can is because the only thing the courts can deal with is fictions. And when you say that you're not a fiction, you're alive, then you're entitled to common law. There's just a whole bunch of things that really sabotages the courts big time. And if you're a fiction, then you're a thing. Things don't have rights, and things are property, and they can do anything they want. And so either you're a fiction, a minor estate, treasury direct account, or you're a living man or woman. If you're a living man or woman, then you're entitled to common law. There's some friends of mine there's a friend of mine actually that's in jail right now that he went and did a plea bargain, which was a major mistake, but he rescinded it there within the time period, and they still have him in their jail. And so what we're going to have to do is a habeas corpus, but it's the argument with the habeas corpus is that it's brought upon the court that he filed an affidavit of life. It was filed into the case. We have the evidence, and we want it introduced as exculpatory evidence. Okay, so you that's what you want this for, is you want to have an evidentiary hearing, and you want to introduce it as exculpatory evidence. And if you get it introduced as exculpatory evidence, that's going to be a big problem for them to proceed, and they're probably going to just drop the matter. With my case, I had filed this into the federal court, and I just asked for an identity hearing, and I was in jail, and I was, I think universe was smiling down on me because I was in the same cell
Is he still going?
as the only other people in the whole jail that went to the law library as workers, as trustees, to go and work in the law library. And so they were helping me. And so that was like wonderful. And so they were helping me. And they went down to the law library and they started asking the supervisors down there about an identity hearing. And they said, identity hearing, what do you want that for? They knew exactly what that was about. And they were doing everything they could not to do it. You see what I'm saying? And so that's a major problem for them. They know exactly what that's all about. Anyway, so this is the one that I went and filed. It's all we're going to look at it today. And we're just going to go over to the, here. This is the Word file right here. So we'll just go over the Word file. Needless to say, it's filed. You can put your image in there. That's my image. Cantankerous old fart. And so it basically says, comes now GlennWinningham, a lawful man, real party interest in this matter, appearing specially under restricted appearance, Rule E8 of Supplemental Rules for certain Admiralty maritime claims, exercising his right to petition the general government for relief of claims made against my estate under presumption of my death. I, GlennWinningham, House of Fern, a man being over the age of 18 years, do witness to state for the public record the following: the public record on file in the Alberta Registrar of Vital Statistics. So in your case, you put the head office of the registry of the birth certificate, wherever it is in your state, you put the address of the head office there. And so that as of the date of this affidavit of life, the entity known as GlennWinningham Fern is still alive and breathing. And that's my 18th birthday. The applicant has not surrendered nor abandoned any claims of life, nor any and all claims of estate, to include but not limited to Glenn Fern, also known as GlennWinningham Fern, and the attachments, Exhibit A and Exhibit B, and we're going to talk about those in a minute. Do affirm I've read the above affidavit, know the contents to be true, correct, complete, and not misleading, the truth, the whole truth, and nothing but the truth. And then I put my right thumbprint in my own blood. And then the witnesses. And the witnesses is the most powerful part. We, the undersigned witnesses, attest that we individually and collectively know the entity known as GlennWinningham House of Fern to be alive and breathing, and that he is not lost beyond the sea, but walks among us upon the land. and that we did witness him affix a signature to the above named affidavit of life, and also to place his right thumbprint in his own blood upon this document. So then I got a bunch of witnesses. If you look at the original, there's like 2 pages of witnesses, 3 pages. So then Exhibit A, corpus juris secundum. You know, I want to check something here real quick. I have it here on my desktop, and I want to make sure. $7.14. Let me look here. I'm just looking to make sure the page is right. Yeah, it's 713. So this is page 713. I was wondering about that. We'll look at that. Matter of fact, maybe I'll just share it right now. The important thing to understand, someone on this group gave this to me, and it was brilliant. That's why it's important to network. That's extremely important. And I mean, there's very little stuff that I got on my own. People sharing and sharing information, and this is where I got this from. There's someone on this group. So I thank you. And it's a networking thing, and that's why I make this stuff available, because you all need it. And so this is Corpus Juris Secundum, which is a set of books in the law library, about 150 volumes. I have a set. And this is book Executors and Administrators, section 16. I'm not sure which book it is. Let me look here. Executors, it'll be under that heading, Executors and Administrators. Jurisdictional requisitions, fact of death. The death of the person on whose estate administration is sought is a jurisdictional requisite. While a presumption of death arising from absence may present a prima facie case sufficient to warrant a grant of administration, if it subsequently develops that such person is in fact alive, the administration is void. It's absolutely essential to the jurisdiction of the administration of an estate that the person on whose estate such administration is granted is dead. This is talking about that minor estate, and notice the footnotes, okay? This is note 1 right there. A living person has no estate subject to probate, and there is no vested right of inheritance in the estate of a living person, and that's footnote 2. And any administration of the estate of a living person is void, and that's note 3. So, and then we go down here. Here's note 1. And it quotes some court cases. And here's note 2. Here's note 3. And there's some court cases here. So if you go to what we did, go back to the Word file. See, we went and modified this Word file. Let's make that bigger. There, can you guys see that better? So it's absolutely essential to the jurisdiction, the administration of a state, that the person on whose estate such administration is granted is dead. and that's Withers versus Root. There's some court cases that I put in there that were taken from those footnotes. A living person has no estate subject to probate. There's no vested right of inheritance in the estate of a living person. And there's the court cases to support that. Any administration on the estate of a living person is void. So that's all. That's why we put that stuff in there. And then we go down this Exhibit B is the Cesta KV Act of 1666. Because that's where this goes to. So this is coming from the Pope. So what they do is they presume you're dead, and dead things they have jurisdiction over. The estate, that minor estate. And if you don't know that's what's going on and you don't defeat their presumption, then they're going to have you in their hotel. And they're going to be collecting revenue off of you. That's why another thing you do is always, always, always sign everything without prejudice. And actually, I've learned something new is without recourse. And there's UCC 1-308 and UCC 1-415. Okay, so I'm going to start putting without recourse too. And without prejudice and without recourse. Without prejudice means that you're reserving your common law rights. And a lot of people don't know how to defend their common law rights. And so that's when you reserve your common law rights, you still have to know how to defend them. And so then without recourse means that I'm giving you a sample of my signature, but there's nothing you can do to me about it. And so I think that's like really important too. So and they give you lots of room, so you can put without prejudice and without recourse. And so this is all the Pope. Okay, they lay awake at night with this stuff, these Vatican Satanists. Okay, and so until this stuff goes away, this is what you're going to have to deal with. So this is the Cesta KV Act of 1666. This is the Word file. I have a certificate of mental competence, but I don't have it in my document because I didn't have access to shrink to get them to say that. But there's someone I've just run across recently that might be willing to do that for me. So that leaves that open. Anyways, so this, if you go here, as says the KV Act of 1666, and then right here, it's got Chapter 854 to establish a code of law for the District of Columbia, the legal estate to be the Cesta KUs, 16 at 31 Stat 1432, 1901, which is now codified at 31 CFR 636.6. And it says an individual means a natural person. A minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. Court means a court of law with jurisdiction over the parties and the subject matter. Entity means any owner of a Treasury direct account that is not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. So what that does is that brings you under the Commerce Clause. Brings that minor estate under the Commerce Clause. And the Supreme Court in a lot of cases, but in particularly in the case National Mutual Insurance Company versus Tidewater Transfer Company, said that the boundaries of the District of Columbia expand as necessary throughout the states of the Union if you're a U.S. citizen. And so that's not what you want to be. Okay, you want to be a man. A U.S. citizen's a fiction of laws. That's that minor estate. That's the U.S. citizen. And so you want to be that minor estate. And what I do is I also challenge the hearsay evidence, okay, because all of that evidence about the U.S. citizens hearsay. So I do a motion to quash the hearsay evidence. And because it's illegally obtained with an illegal search and seizure, and I haven't admitted it, so therefore it's inadmissible. And so when you start doing that stuff, and then you sign everything without prejudice and without recourse. I'm going to start putting without recourse from now on too. And so that's the single most important thing you can do. When you sign it without prejudice, you're basically reserving your common law rights, and you're saying there's no contract here. And then without recourse means that you can't do anything to me because I put without prejudice or without recourse. Can't do anything to me. It's I'm not giving you permission to do anything to me. And so that it's a double-edged issue. So anyways, this is how I got myself out of jail. Okay. And this is how I'm going to get a settlement too, because they weren't getting paid. When you just give them a signature, they take that signature to the Treasury, and then they get paid. And so you want to make sure that they're not getting paid to put you in their jail. And so there's just a whole bunch of reasons why you want to put without prejudice, without recourse, and that affidavit of life, and get it introduced. You do a motion to introduce it as exculpatory evidence. Have an evidentiary hearing. I want to have an evidentiary hearing to introduce this as exculpatory evidence. And now that I've got this thing filed, you saw the one that I had filed in the federal court. It's document number 113. And so I'm going to, I'll remember that. 113 is a nice, easy one to remember. And if I ever have a problem, then I'll say I want document number 113 in this federal court case. I want it introduced as exculpatory evidence in this matter. And I'll get a certified copy. You can order a certified copy easy enough. I actually have a certified copy. I just have to print it. And so the one that I showed you, there's a certified copy. Anyways, so then that's like major problem for them. Okay, so you're signing everything without prejudice, without recourse, and I have exculpatory evidence that I want to introduce that shows that I'm not dead. And they don't put living souls in prison. Okay, they put things in prison. Okay, the custodian is a custodian of things, and the things that are in prison are slaves. Okay, and so the slave is a thing. And so when you start doing this, and you basically say that I have access to common law, and I'm on the land, and I'm not in the District of Columbia, and you start bringing all these issues up, I mean, it's major problem for them, and they're gonna. There's no doubt in my mind that they saw where I was going with that stuff, and I have a pretty good memory, so I was able to bring up that National Mutual Insurance Company versus Tidewater Transfer Company and summarize it. I can summarize it pretty good. And they had these tablets in jail, and so you could look that stuff up. And then the guys that I was in the same room with all worked in the law library, so they go look it up for me. I tell them I want this case, National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948, and they'd go and get it for me. They print the whole thing off and make copies if I wanted them. It's all free, and so I was able to do that. And now the stuff that's recorded is already recorded into the federal court, and it's a certified copy. If you want to introduce any evidence of any court document, it's got to be a certified copy. So it's easy enough to get a certified copy. And so that's what I was working with. I was working with a friend of mine to have him order a certified copy, and I was going to have it taken to the lawyer and have it introduced. as evidence. And the lawyer knew that. That was stuff I'd sent to the lawyer. When the lawyer came to see me, they said, "We got your letters, and the case has been dismissed." They knew where I was going with it. And so they dismissed it. They just, and it was the same judge. I did a motion to quash the warrants, and we talked about the motion to quash the warrants last week, and I showed that it's a bill of attainder, and that there was no court seal on the warrant as required by the Authentications Act, and therefore it's not an authentic warrant. It's color of law. It's a felony. They violated my rights under color of law. They intended to murder me. Okay, because I have a right to resist an unlawful arrest with lethal force if necessary. And if I would have exercised that right, then they would have killed me. And so that's attempted murder. And so this is all going to come up when we want to settle. I'll tell you right now, you tried to kill me. And so this is all going to come up. And so I think, I think you ought to just settle this matter because you don't want this stuff coming out that you tried to kill me, and so this is really it nails it really good, and it creates a problem for them big time. Let's look at YouTube and see if there's change your status. Well, you don't have to change your status. You just assert yourself as not the minor estate. That's all you have to do. The 1020 Form 1020 template is uploaded with. If you go to some of my older, when I say older, more than a month or two old videos, you'll see them in the show notes. Okay, they're in the show notes. There's a link to them in the. It's a Google Docs link, and you don't manipulate it. Okay, I will not give you access to it. You download the file, and then you can manipulate it all you want. Okay, so I'm not going to give you access to the file. So don't be contacting me wanting access to the file because I won't be giving it to you. You download the file onto your hard drive, and then you can go ahead and manipulate it all you want. Yeah, without recourse and without prejudice. And so anyway, so that's all the stuff on YouTube that I'm concerned about. So the important thing to understand is that you want to do an affidavit of life. You want to get it recorded into the public in a court case somewhere, and get a certified copy. The federal courts are actually the best because then you get a certified copy from them, and because what they do is they put a header and a footer on the page, and they'll certify it, and then it's obviously certified, and you can introduce that as evidence in any case. Just a second, hold on, please. Hello.
Hey Glenn, it's Courtney. I've got Bobby on the phone.
Okay, I'm in the middle of a live stream, but go ahead. I paused it for a minute. Sorry?
Did Courtney send you over the motion to vacate the plea?
Yes, she did. I haven't looked at it yet. I was going to look at it, but what I was suggesting, I talked to some people here, and what we should do is basically because you rescissioned your plea, and so it's rescissioned, and so we should do a habeas corpus, is what we need to do, and we bring up that it's fraud upon the court. That they got the wrong guy. It's a living man that's in there because we got your affidavit of life that's filed, and so what I was told we should do is a habeas corpus.
Do you have one that we can get and go from there off of it? Because I'm just looking on borrowed time because this judge is going to be going on leave for over here soon.
Well, it won't be the same judge. It'll be a different judge. And what they do with the habeas corpus is they open a new case. And so what we do, it's a standard. I think it's a 1341, or it's a standard habeas corpus for someone in federal custody. And I'll help Courtney fill it out. And but the argument is that the affidavit of life has been filed. That a man is being held in custody improperly. It's not a thing. It's not the minor estate, and because of the evidence. Matter of fact, what I was suggesting to Courtney is to have an evidentiary hearing. Have an evidentiary hearing. Get the judge to introduce it into the evidence file as exculpatory evidence. When's the judge going on leave?
Well, he's supposed to be retiring, but he's leaving for a month, and then he's coming back to handle a couple of his cases before, I guess, a full-blown retirement.
Okay, so
This is supposed to be my sentencing date.
So we need to do an evidentiary hearing and have that affidavit of life introduced as exculpatory evidence.
What do you think about the motion to vacate the plea? Because, I mean, like, this lawyer just doesn't want to do a goddamn thing, and he's just sticking it all in my lap. But, I mean, that then brings up again if an appeal or the Supreme Court or whatever I need to go to next.
Yeah, I wouldn't. It's up to you. I think that that's redundant because you've already got the affidavit of life put in there, and you rescissioned it.
The caller has hung up.
He rescissioned it.
I'm sorry, I'm listening. Yes.
He rescissioned it. Is the rescission on the record?
Yes.
Yeah.
That they will not recognize it.
That's okay.
And
It's on the rerecord. It's on the record.
Bobby has referred back to it multiple times, saying it's docket entry 350-1, and I guess it was put in there as attachment or something. I don't know. That clerk of court is about an idiot, if you ask me. But she didn't put it in there, right? But it is still on the docket. I mean,
So
it could have been looked at.
what
And
about the affidavit of life? Is there a docket number for that?
yes.
Okay, so that's all that matters.
I don't know what it is off the top of my head, but I know I have it on my computer saved, and I know it has the PACER stamp at the top of it to show that it is docketed.
Okay, so
And
what?
He also we sent a cover letter because we did that back, a little while ago. We sent a cover letter with that to say that he wanted that docketed on the record, and then he also wanted it in the evidence file. Now, did they do that? I don't know, because we don't have access to that file.
So let's do a motion to an evidentiary hearing for a motion to introduce that affidavit of life as exculpatory evidence is what I would do, and send it to the lawyer and see if he'll introduce it. And if not, Bargrave his ass. But meanwhile, we got to get Bobby out of there. And so, tell the lawyer that's what we want to do. Is we want to do introduce that affidavit of life as exculpatory evidence. Okay. And then once we get that introduced as exculpatory evidence, then the habeas corpus is going to be basically a foregone conclusion, I think. And they'll kick him out of there because of the fact that but we need to see exactly where his rescission is and proceed that way. Okay. But
he had done that rescission of that plea back months ago. I mean, literally just days after he signed that.
Yeah.
He was like, I shouldn't have done that. Like, no. I mean, he was threatened. He was forced. He was told, like, you either sign this and go home with your family, or tomorrow when the jury finds you guilty, the government will move to have you held until sentencing. and Bobby had zero time to read the 17-page plea deal. He didn't even know what was in it. He was 5 days into trial at that point. He was tired. He's mentally just about to lose his mind. You know what I mean?
Yeah.
Fighting
Yeah.
a federal case by himself. It's just, I mean, with your help and stuff like that. It was a lot, and so he signed it, and then turned around just right after we got home. He sent that in, but they have still.
Thank you guys for waiting and hanging in there.
It's not even there, and the lawyer told him that nothing else will be looked at until they have a hearing over vacating the plea, and he has to do a proper motion to vacate the plea.
Well, so I mean that's not bad. So I'll look at that motion to vacate the plea, and so the lawyer, he doesn't like that motion. Then is that what he's saying, or what?
Oh yeah, he doesn't like it. He doesn't like anything. He doesn't agree with any of Bobby's stuff. Bobby has sent him the parallel table of authority. He sent him all of that, and Reagan has just said, "I don't understand it. I've read everything, and I will not file anything into this case that I don't believe in and that I can't find."
Just waiting for him to come back. He had a phone call. I guess
he won't file. Well, the affidavit of life is already filed, and tell him we want it introduced.
We wanted to do the amicus. We wanted Reagan to file that in as an attorney rather than take your name off of it, and Reagan to file it in. And he says it doesn't make sense to him. He doesn't understand it, and he will not file anything into Bobby's case unless it has factual legal basis.
Did you send it to Trump's pardon attorney?
Yes. The Edward.
Yeah, Edward Martin. Edward Martin Jr. Yeah.
Yes.
Okay. Well, so the affidavit of life. I mean, we need to. I think that's. We need to have that introduced as exculpatory evidence, and so that's where we need to go with it, and I think the lawyer ought to know what that's all about, and but that's all I can say. Is we need to get that introduced as exculpatory. Tell them we want to have an evidentiary hearing and introduce that as exculpatory evidence, and so we'll see. Okay, I'll look at that motion. I mean, I'll look at it here tomorrow, and I was hoping to do is get that affidavit of life introduced as exculpatory evidence, and I sent this stuff to my lawyer, and they understood it. And they didn't even. They said I got your stuff, and they didn't say anything about what I'd sent them. But they said the case has been dismissed. So they.
That's what's so crazy to me is this guy has been practicing had his own bar card for who knows even how long, and it seems to me like he has zero interest in helping Bobby. One of the reasons they kept Bobby in West Palm instead of in the Miami detention center is because Reagan, this attorney, which is in West Palm, could go see Bobby. And, if he needed something or whatever, the guy won't pick up this phone. He's went and seen Bobby one time, and Bobby started yelling at him, so he picked the stuff up and walked out the door. And I've been in contact with him. I've been in communication with him asking, hey, can you file this? Can you do this? And he won't freaking do it. And Bobby gets so mad because, I mean, can you blame the guy? You know what I mean? I understand why he's getting so mad. But Reagan literally told me on an email, that's the attorney, he was like, I will not file anything that I do not find factual legal basis in. So I told Bobby, I was like, if we want anything filed, I'm just going to mail it because I'm wasting days over here fighting back and forth with Reagan on filing it or not. And so I don't know if he's just a government loving guy or what he is. Surely he's got to understand this stuff.
Have you bar grieved him?
No.
Well, I mean that's a good way to get him in there begging to get off the case.
Okay. Let me put that in my notes.
File a bar grievance with the Florida bar. He's with the Florida bar, so you can bar grieve his ass. and then maybe he'll be a little bit more conciliatory. Anyways, I'm on my live stream right now, so I got to let you
Okay.
go. I'll call me tomorrow. Okay.
Okay, will do. Thank you, Glenn.
Okay. Yeah. No problem. See ya.
Okay, bye.
Bye. Okay, I'm back. I had an emergency. Whoops. Let's see here. Okay, I'm back. I had an emergency. I went and muted my mic, in fact, and so. So the important thing here is this affidavit of life and get it introduced as exculpatory evidence. And there's some of the stuff that we do these lawyers don't want to cooperate with, and sometimes you just have to bar grieve them and bring heat down on them. But I think that most of the lawyers, I did the motion to quash the warrant and the identity hearing, and the lawyer, they didn't say anything. They said, we got all your stuff and the case has been dismissed. That's all they really said. And so it sounded like that she went and explained to him where I was going with it, and then I did the confession and avoidance, that I'm a senator and I've been with the Republic of Texas for 20 years, and we were trying to do something to help people. But anyway, so they didn't. I guess they didn't want to deal with it. They dropped it. They dismissed it. They didn't drop it. They dismissed it. So the important thing is that this affidavit of life is absolutely fatal to what they're trying to do, because they want to assault you with that minor estate. That minor estate they can hold in their warehouse, and it's all about trustees and trusts. Matter of fact, what I was going to do next is go through this mandatory judicial notice of 12 presumptions, because and we've been through that before, but this goes back to the why they're dealing with the trust law. Okay, this is all trust law. Excuse me. This is trust law, and it's the Vatican, and that's what they put in their hotel. And this will show you. Excuse me. So, does anybody have any questions about the affidavit of life, first of all, before we go on with the trust law?
Go ahead, overseer.
I have a question. You said you filed this to federal court, or where did you file it?
Yeah, this is filed in federal court.
And your case is in a state?
Yeah, the state court. They charged me with 3 felonies in the state court. Yeah, true.
Then you went to federal court. Where did you go to federal docket, or where did you file it?
This was previously filed, if you look here, May 30th. Okay, so it was a long time before they went and charged me with the 3 felonies, and so I knew it was in the federal court, and so it's easy to get a certified copy and file it into the state court, because that's the only requirement. Okay, when you file any legal document into the court, if you look in the rules of evidence, it has to be a certified copy. So you got to make sure that it's certified. If you go and just file a copy in there, then they're going to look at it and smile at you and be real nice and ignore it. Okay? The only thing that you can file in as evidence is certified copies. And so you got to make sure that it's certified.
Okay, so you had a court case in federal, and then you file it into court case. I see. So when people do not have a federal court case, then they could go to federal docket. They call it a federal docket. You could file, like, they charge you like $49 Pennsylvania. And
Well, you can, like some people open a case with the like Queen was saying earlier, some people open a case with the probate court, um, and you can do that. There's lots of ways that you can open up a case, and so that you can file it in there, so that you have it filed into a court. Um, you could file it at the county recorders. Okay, again, it has to be certified. If you're going to introduce it as evidence in any court case, it's got to be certified.
Okay, so certified, and then you don't have to authenticate it by Secretary of State.
Sorry, I can't hear you.
Can you just get a certified and not authenticated by Secretary of State?
I didn't say anything about getting authenticated by the Secretary of State. I just said certified.
Okay, just a certified. Okay, that sounds good. New York State, they charge public notice $5. Just recording.
Okay, there you go.
It doesn't matter how many pages. $5.
Yeah, that's very reasonable. Okay, so let's keep moving here. This next one is mandatory judicial notice of 12 presumptions. This was also filed into the federal case. I was planning on introducing this as exculpatory evidence into the state case. So it's 23 pages. So let's start going through it here. All facts stated herein are true, correct, complete, not hearsay, not misleading, but are admissible as evidence if not rebutted and proven inaccurate. And if testifying, I shall so state. I'm a flesh and blood man, a sovereign individual in a collective capacity with other sovereigns. I have standing capacity to act in the lawful matters herein. I have personal, executive, and documented knowledge of the facts stated herein. I have no first-hand knowledge of my date of birth, except to say that I was told that I was born on or about the year 1957. Any evidence anywhere of my birth is hearsay and inadmissible in any court, because both my parents and the attending physician at the time are now dead, and I have not had the opportunity to cross-examine them in court to determine the veracity of their evidence. Having said that, I do remember finishing high school in the year 1975, therefore I'm well past the age of majority. And here is the certification document statement by the clerk. And you notice that these headers, this case 424 CV document 112. This is all stuff that the court puts in there. So that's evidence, that's their headers, part of the certification. And not every page has that certification. Certified true copy of an instrument on file. That's all that matters. That's what they require for a certified copy. So to continue, in absence of the evidence, I'm a free man on the soil of Texas and other American states from time to time. I'm devoid of any knowledge of surrendering or volunteering myself as a government employee or of the armed forces of any country, and devoid of any knowledge of surrendering myself to the District of Columbia and their U.S. citizen scam, or their Sesticate Trust scam, or their Vatican Corporation or fictitious entity scam, as found in the Affidavit of Corporate Denial, which is recorded at Pinal County Recorder at fee number 2013-032373, and hold any respondents to the strictest proof to the contrary. I have many good and honorable servants that work for governments on Turtle Island at various levels, and I have no idea what they get paid, but in my opinion it's not enough, because we need people to hunt down thieves and murderers and keep the peace. And I'm cognizant of my duty to come to their aid when needed. And when they perjure their oaths and engage in unlawful activity, it's my duty to bring their crimes to light and do everything I can to make sure they're brought to justice. The use of statutes, codes, rules, and regulations or court citations within any document created by me at any time is only notice that which is applicable to government officials and not intended, nor shall it be construed to mean I have conferred, submitted to, or entered into any jurisdiction alluded to thereby. Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey. 1787 is my fourth great uncle, which means on posterity is found in the preamble. We the people of the United States, in order to form a more perfect union, establish justice, ensure tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. And I'm entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and all the laws of Texas are civil laws. Right of blood and kindred cannot be destroyed by any civil law. I think I'm going to OCR this, because for some reason it doesn't seem to be cooperating. So we'll let it OCR for a few minutes, and then I should be able to do some things with it. So this is a mandatory judicial notice of 12 presumptions, and it talks about the 12 presumptions that we're going to go through. This goes through a little history first. And the one that I got was 5 pages. This is 23 pages. And so I have the Word file of the one I got. And so if anybody wants the original that doesn't have all the stuff added into it, and wants to use that instead, I'll be glad to make it available. I'll probably just upload it to the group, the Word file. And so this one here is modified. The other one is not modified. And so that you can, if you don't want to use all this stuff. But I think it's all relevant, and so it's a problem for them when you start bringing up this kind of stuff. Now, some of the lawyers don't want to deal with it, and so so we'll see. We'll see. That's all I can say. Just going to let this, it's on page 13, so it's got about another 10 pages to go. And then I'll be able to, we were on page 2, I think. As soon as this is done, see, this is all Roman law, that trust law. It's all trust law, and so this is the bar. Yeah, don't get me going. You're going to get me going. So now we'll save it. See, now look at that. Hey, I can highlight this stuff. Yeah, that's what I want. Okay, so let's move on. And this court is operating under power which is derived from me as posterity. The maxim says the power which is derived cannot be greater than that from which it is derived. This is Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for me to give any of these wrongdoers or their bar member handlers or this court any authority over me. And John Marshall, the Chief Justice of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for me to confer sovereignty which will extend over me. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. And I'm exempt from these wrongdoers and their Vatican corporation and their bar member handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's Kalanicoa versus Polyblank. And I require this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or their property belonging to the United States, which is the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. That's Article 6, Clause 2 of the Constitution. And we, the people, failed to be U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced, and the several states had assumed their sovereignties. Before this period, there was no citizen of the United States. And BAR as an acronym stands for British Accredited Regency. Regency is the office or jurisdiction of a regent or body of regents, because all BAR members are appointed by Inns of Court. Inns of Court are certain private and unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar, which is located in the Pope's owned and operated dependent city-state located in the city of London, called the Kingdoms of England and Ireland, now known as the United Kingdom, and the Crown since the concessions of England to the Pope, 1213. And this is the concessions. We will establish perpetual obligation and concession. We will establish that from the proper and special revenues or aforesaid kingdoms for the service of customs which we ought to render for them, saying in all things, this a penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and Easter, 500 marks, 700, namely for the Kingdom of England, and 300 for the Kingdom of Ireland. That's concessions of England to the Pope, because King John gave them to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of Pope. Not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III and received them again and hold them under him, under the rent of 1,000 marks. Which means all bar members are foreign agents of the Vatican, which is why they're here under the foundation of the Federal Bar Association, 35 U.S.C. 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, and the Pope's owned and operated dependent city-state in the City of London, called the United Kingdom, and the Crown created the Sestike V Act of 1666. And this is Tomlin's Law Dictionary again. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holes, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use. Use, standing for usufruct, by the way, and receiving the actual profit, while a season of the lands remained in the nominal fief to be held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to a sestike use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing, and which was brought into America first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, a rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature, and from international law. Black's Law Dictionary, 4th edition. And then the Code of Law for the District of Columbia in 1901. An act to establish a code of law for the District of Columbia, the legal estate to be the Sestike Use at 31 Stat 1432, which is now codified at 31 CFR 363.6 and are unconstitutional because municipal law is a law of the dependent papal ecclesiastical city-states. Civil law, municipal law is that which every sovereign kingdom state has appropriated to itself. The appellation of municipal was originally conferred on the laws of the municipia, or dependent states. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean between Tuscany, Modena, and Lombardy on the northwest, and Naples on the southeast. Area 17,822 square miles. Population in 1833, 2.7 million. Capital Rome. Population 153,000. Government and elective monarchy. The Pope for the time being the absolute sovereign with a consulting assembly of cardinals. That's Waterston Encyclopedia of Commerce and Mercantile Law. Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. It's also called canon law, the civil or canon law, civil or Roman, and canon law. And that's Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771, which is now the Vatican, and it continues to this day. The Lateran Pact, Article 4, 1929, the sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. Unconstitutional because Article 1, an amendment, Congress shall make no law respecting an establishment of religion, and is unconstitutional because this is what precipitated the War of Independence. And this is causes and necessities for taking up arms. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish the order and the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. And the organic law of the Declaration of Independence shows it was listed as reasons for a Declaration of Independence from the Pope's owned and operated tyrant. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. Can only be talking about the Pope's Roman law and the minor estate as an entity, because an entity includes the estate of a living person such as an incompetent or a minor. And a minor can be anyone over the age of 18 who has failed to take control of the securities in the Treasury direct account. And the minor estate, 31 CFR 363.6, is a fiction of law which was invented by the Roman praetors under the pretense of doing equity. This is Bouvier's Law Dictionary, 1856 edition, page 520. Fictions were invented by the Roman praetors, who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fictions is the resource of weakness, which, in order to obtain its object, assumes as a fact what is known to be contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fiction of law owe their origin to the legislative usurpations of the bench. And fictions of law, which is necromancy and satanic. Okay, King James Version, Deuteronomy 18, 10-12, which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever of such district not exceeding 10 miles square as may by the cession of particular states and the acceptance of Congress become the seat of government of the United States. To deceptively assault people with a quasi-contract. assumpsit, based at first upon an express promise. It was afterwards supported upon an implied promise, and even upon a fictitious promise. And competed with equity in the case of essentially equitable quasi-contracts growing out of the principle of unjust enrichment. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it. And that's Salmon on jurisprudence, which requires the Pope's minor estate, U.S. citizen, or other fiction of law. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law, because under the Commerce Clause, the boundaries of the District of Columbia expand to anywhere on the planet. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948, U.S. Supreme Court. Which is why in the Kavanaugh hearings, when he was being interviewed for a Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And because plenary power is a dictatorship under the Pope's Roman law. And so then here's some definitions of plenary, which is also a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And that's what this stuff here talks about. Because judges only hold office during good behavior, and judges in bad behavior engaged in fraud upon the court, and operating as an administrative clerk, masquerading as a judge under Roman law is bad behavior, which are non-judicial proceedings. Because whenever a statute's involved, the Pope's fake judge is actually a bought and paid for clerk masquerading as a judge. And bills of attainder are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and Article 1, an amendment which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law, and because they have imposed martial law rule. And this is causes and necessities for taking up arms, and I already read that. With the bankruptcy emergency, it's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. You know, in my opinion, he committed treason when he did that. HDR 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolving the sovereign authority of the United States and the official capacities of the United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. And that's U.S. Congressional Record, March 17, 1993. Since March 9, 1933, this is taken from U.S. Senate report. Notice the same date, March 9, 1933. March 9, 1933. The United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule for 40 years. Freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. Because martial law is a law of emergency and necessity, there's three kinds of martial law. Full martial law is when actually invaded by a foreign enemy or insurrection, troops are put on the street. Martial law proper is the law of the armed forces, and martial law rule, a law of emergency and necessity used during peace times, can go on indefinitely, and that's taken from Ex parte Milligan. And the Pope's bar members on the bench tell you I can do anything I want. And this is Diet versus Turner. This is a war of the intrusion of the civil law upon the common law. The Court of Diamond v. Harris calls the civil law statutory law superior equity, and this is a quote from that Diamond v. Harris. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt a civil law even though it has the merit of superior equity. And then Diet versus Turner goes on. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And these judges all the time tell you I can do anything I want in here. And that's non-ratification of the 14th Amendment by Judge A.H. Ellett, the Utah Supreme Court, in the case Diet versus Turner. Because under martial law rule, equity does not follow the common law. And this is a divorce case. Every system of law known to civilized society generated from or had as its components one of the three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter, Christian. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. 1941, which makes it satanic. And Satanists are using the Pope's Roman law of capitis diminutio maxima, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. Swept away with it all rights of citizenship and all family rights. That's why you don't want to be in bondage. I mean, bondage is where they issue a bond to populate the prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. Excuse me. And because of the administrative proceedings under the Pope's Roman law, there are more people in prison in America as a percentage of the population than there are in communist China or the Soviet Union, and the worst dictatorship in history. And if there were Christians here, the bar members doing it would get their necks stretched. Deuteronomy 24:7. If a man be found stealing any of his brethren or the true children of Israel, maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the Vatican and their Roman law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. When you sell them into slavery, you destroy their lives, all of which has been planned and orchestrated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. And the Pope, the Vatican now owns and operates the bankrupt 1871 corporation, 16 Stat 419, as evidenced by the Roman Achaea military staff that is planted on all conquered nations, as sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall of each side of the Speaker's podium in the U.S. House of Representatives, which is also why Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told the members of Congress, "We can't read this bill until after we pass it," because she was taking instructions from her Vatican handlers all of which is evidencing the fact that the 1871 corporation, 16 Stat 419, currently operating in the District of Columbia, is a Vatican-dependent city-state. And here's arrows. There's the Roman Achaia military staff, and these are the two Roman fascia. And the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state and criminal matters that talks about concurrent jurisdiction in other states. When the same matters are prosecuted in other states, the provision enforced in Vatican city-state on concurrent jurisdiction shall apply. And that's apostolic letter issued motu proprio, entered into force 1st September 2013. And the Vatican's Pope Francis came and addressed his own and operated Congress on 24th of September 2015, and the Pope's satanic bar members are assaulting people with the Roman fiction of law, minor estate, 31 CFR 363.6, sesticaeus, usufruct, trust, necromancy, with the following presumptions that are rebutted as follows. The presumption of public record is that any matter brought before a court is a matter for the public record, when in fact it's presumed by the members of the private bar guild is a private bar guild business matter. This presumption is rebuked and rejected, and is hereby demanded this matter to be on the public record. The presumption of public service, that all members of the private bar guild who have sworn a solemn absolute oath to their guild and then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. This presumption is rebuked and rejected, and the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath, and possibility of this matter being a private matter is rebutted. All persons engaged in the matter at hand are deemed to be in the public service as public servants. The presumption of public oath is that all members of the private bar guild acting in the capacity as public officials who have sworn a solemn public oath remain bound by that oath, and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. It is openly challenged and demanded. The presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. It is openly challenged, and such individuals must recuse themselves as having a conflict of interest and cannot stand under the public oath. The possibility of this is rebutted, and all public servants acting on behalf of this matter are required to state all sworn oaths, both public and private. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn the public oath in good faith are immune from personal claims of injury and liability. It is openly challenged and their oath demanded. That presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from personal accountability for their actions. This is absolutely rebutted. Any person acting as an agent for a nameless, faceless corporation is wholly personally responsible for their actions on behalf of the Vatican's corporation. All actions incurring any degree of injury will incur notice of injury, including severe financial penalty. The presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually by invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction or position as the accused and the existence of guilt stands. This presumption is absolutely rebutted on this occasion, on past occasion, and in future occasions. However, at no time was I absent nor silent with regard to the matters at hand. The presumption of custody is that a custom, if the summons is not rebutted, it stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, and not flesh and blood, soul possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands. You are a thing and property, and therefore lawfully able to be kept in custody by custodians. This presumption is absolutely rebutted. I'm alive and well and a man and nothing in custody by custodians or guardians. I'm not a thing. I am not property of the court. Under no circumstances may I be detained in any way whatsoever, not at any time, past, present, or future, and there is no surety in this matter. The presumption of the court of guardians is the presumption that you may be listed as a resident of a ward of a local government area. You are a pauper and therefore under the guardian powers of the local government as its agents, as a court of guardians. Unless this presumption is openly challenged and demonstrated, you are both a general guardian and general executor in the matter trust before the court. The presumption is rebutted that I am by default a pauper, a lunatic, and therefore must obey the rules of the clerk of guardians, clerk of the magistrate's court. The presumption is absolutely rebutted, and I am at all times a man, sui juris, and have possession of much more than 21 silver eagle coins with the face value of $1, and therefore fail to be a pauper, and there is no surety in this matter. The presumption of the court of trustees is that the members of the private bar guild presume you accept the office of trustee as a public servant and the government employee just by attending court. As such, the courts are always for public trustees by the rules of the guild and the court, unless this presumption is openly challenged, to state you are merely visiting by special visitation, by special attendance, to clear up the matter, and you are not a government employee or a public trustee in this instance. The presumption stands and is assumed in one of the most significant reasons to claim jurisdiction simply because you appeared. This presumption is absolutely rebutted. Absolutely no jurisdiction at any time may be claimed by the private bar guild and the court over me. The office of trustee is rejected. The role of public servant and government employee is rejected. There's no surety in this matter. I'm entitled to common law, not Roman law, as required in Article 6, Clause 2 of the Constitution for the United States of America. This Constitution and the laws of the United States which shall be made pursuant thereof, and all treaties or which shall be made or under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Because law of the land phrase is convertible with the phrase common law, the principle that no person should be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed by on the 19th day of June 1215, declared no freeman shall be taken or imprisoned or deceased or outlawed or exiled or otherwise destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or by the law of the land. It has been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary action of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted, Magna Carta, the phrase law of the land had reference to the common law and is a fundamental rule in common law. And that's Book 16, American Jurisprudence, 2nd edition, Constitutional Law, Section 543. And common law and law of the land has always been here long before the government was in here. This is Hale versus Hinkle. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. The presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoint the judge magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter, unless this presumption is openly challenged to demonstrate you're both a general guardian and general executor of the matter. Before the court, the presumption stands and you're by default the trustee. Therefore, it must obey the rules of the executor, the judge, the magistrate. This presumption is rebutted if a man in your minor estate, 31 CFR 363.6, was created by fraud and deception by the Pope, and the Pope's owned and operated Crown of England, created the Cestic AV Act of 1666, and I require the minor estate be dissolved and liquidated immediately. And I do not care what you do with the fake money in the Treasury Direct account, because you can put it up your rectal orifice for all I care. There is no money in this, no surety in this matter, but I demand that it be dissolved and liquidated immediately. The presumption of executor de sans tort is the presumption that the accused does seek to assert their right as executor and beneficiary over their body, mind, soul, living man. They are acting as executor de sans tort, or a false executor challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of the true executor and has the right to have you arrested, detained, fined, forced into a psychiatric evaluation. Unless this presumption is openly challenged by not asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to be executor de sans tort, the presumption stands, and a judge or magistrate of the private bar guild may seek assistance of the bailiffs or sheriffs to assert their false claim. This is rebutted. Under no circumstances may the judge attempt to assume the role of executor, and before any personal attendance before a court is undertaken to discuss matters at hand, the judge will need to put in writing that this is clearly understood, fully disclosed, acknowledge that the false presumption, there is no surety in this matter because it's a fraud and a nullity. I want nothing to do with your minor estate or your Roman law, canon law, and consider it to be satanic and an offense before God. You can put it up your rectal orifice. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge, magistrate, executor has the right to have you arrested, detained, fined, or forced into psychiatric evaluation unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any ordinary presumption. Then it stands by the time of pleading that you are incompetent, that the judge or magistrate can do whatever they need to keep you obedient. This is rebutted. The law is under scrutiny for its contribution to the current state of the planet, this distribution of rights and resources, the obstruction of divine law, and discussion regarding such matters. No privilege or deeming us incompetent is permitted. This is all the Pope's Roman law, canon law, and unconstitutional as described herein. The presumption of guilt is the presumption that has been assumed to be a private business meeting of the bar guild, and you are guilty, whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of trust and motioned to dismiss with extreme prejudice into the public record or called demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. This is rebutted. Under no circumstances is a presumption of guilt allowed, as I am redeemed property of my Creator, forgiven of all sin, as I a living man, as evidenced by the affidavit of life that's filed into this case and elsewhere. Before God, angels, and anyone who reads this as a witness, I shake the dust of the earth from off my feet against all the Vatican bar members involved in this matter. Matthew 10 and 14, Mark 6 and 11, Luke 9 and 5, and your screen for low intelligence jarhead thugs. And we will be talking about this on Judgment Day before the one true God. Signed and sealed in red ink on the land under penalties of perjury without your Vatican corporation. Yeah, and that's about it. So what I can do is I will upload the Word files, and people can use them. Let's see here. I will upload the Word files. Of the Affidavit of Life and the mandatory judicial notice. But I'll upload the modified one and the regular, the unmodified one, and you can manipulate them to fit your own situation. You might not want the modified one. Maybe you do. I don't know. It's up to you. Anyways, these are the single most important thing you can do, the Affidavit of Life, and get it introduced as exculpatory evidence. I just can't stress how important that is. And just look at it on YouTube. Anyways, this has been going on for a couple hours, so we're going to wrap this up. Appreciate everybody. Oh, does anybody have any questions before we do wrap this up? Now's the time. If you have questions, now's the time. That mandatory judicial notice, there's a lot of reading there, so you need to read that through and get comfortable with it. You might want to use the basic one without all that stuff that I added in. So it's up to you.
I appreciate it. Thank you for doing that.
No problem, and glad I could come on. I'm sorry Lori wasn't here, but it's this is something that we all need to be doing. Is that Affidavit of Life, and they presume you're dead. This is all Roman law, and you have to protect yourself, otherwise you're going to get sold into slavery. That 12 presumptions defeats the presumptions they have. But if you go and get that Affidavit of Life recorded, that makes it really difficult. And then if there is a case, introduces it as exculpatory evidence.
Glenn Yeshua had his hand raised. Go ahead, Yeshua.
Brother, it was just and greetings. Just to give one many thanks and gratitude for all the hard work that one put into this document, and for gracing us with the ability to have it and that it be used in the proper manner. And we just wanted to give one accolades for that, and many thanks for that. And
well,
we don't have the words. We don't have the words to thank one enough.
It's I didn't get it for free. I mean, people shared it with me, and so I can't keep it to myself. I have to spread the word. When I was 16 years old, I was given a patriarchal blessing, and I was told, "Unto whom much is given, much is expected." And so I feel like I have to tell people about this, and so use it widely. And very little of my stuff have I just figured it out myself. I can tweak it and adjust it and improve on it, but a lot of my stuff I've gotten from other people, and so it's amazing how much stuff I've collected from people over the years, and invariably it just lands in my lap, and I have to spread the word. I want to be, really, when it comes down to it, I want to be clean from the blood and sins of this generation, and so I need to spread the word and let as many people free themselves as can. So thank you for the comments, and I'm glad to do it.
Where will this be shared, brother?
Sorry?
Where will it be shared, the document?
I uploaded it to my page on Telegram on this group, on the
Many
WeRLaw
thanks.
group. There's my page, and I uploaded it there. So the Word files are uploaded, and you're welcome to go ahead and download them and use them as you need to. Okay, well, I
Many
guess
thanks,
we'll
brother.
call an end to it. And thanks everybody for listening. Thanks for your interest, and it's a networking thing.
Glenn,
Yes.
I'm sorry to interrupt you. Overseer had her hand raised.
Yeah, Glenn, I have a question.
Okay.
In your document, it says a minor means a decedent of estate, also including a living person estate. Is that true?
Yeah, for sure.
Both of
Yeah.
them. Okay.
Yeah, that's you have to look that up. It says in the Code of Federal Regulations, it says that.
Because people were saying that living estate they do not have a jurisdiction, and
Well,
but I guess they're still minor.
the only thing they don't have jurisdiction for is a man or a woman. Okay, if it's an estate, it's a dead thing, it's a piece of property, it's a thing, and they have jurisdiction over that, and that thing doesn't have rights. Okay, so I don't know who you're listening to, but the only thing they don't have jurisdiction to over is a man or a woman, and if they can somehow presume that you're dead, then you have no rights.
Yeah, I guess living estate, if they're minor, yeah, of course, that's under parent patria doctrine.
Anybody else, Queen, have their hands up?
Nope.
All right. We'll see you next week. Same time, same place, same channel.
Sounds good. Have a blessed week.
Thank you, and you guys do the same.